A silence that lasted through court hearings, files, and whispered theories has finally shattered, and the confession that broke it could rewrite everything we thought we knew about Charlie Kirk's death. Hit subscribe and turn on the bell now so you don't miss the next developments on this story and more. When someone accused of a violent crime refuses to speak, that silence becomes more than an absence of words. It becomes an active force shaping how the public, family members, and investigators understand the case. For months after Tyler Robinson was arrested, that silence did the work of mystery. It left prosecutors dependent on physical evidence and electronic records. It left defense lawyers limited in how they could humanize a client. It left families and neighbors with questions that had no answer. Silence in these cases has several functions at once. On a legal level, staying quiet is a standard tactic. Anything said can be used in court. For someone with counsel, refusal to talk can be strategic, designed to prevent self-incrimination while defense teams assess what charges will stick. But silence also carries emotional weight. Loved ones want closure. Witnesses want an explanation. Reporters want a narrative. Without a defendant's voice, speculation fills the gaps. The months of silence in Robinson's case hardened public perceptions. People read the charges and the evidence and filled the empty space where motive should have been with assumptions, that he acted alone, that he was cold and calculating, that there was nothing beyond him to explain what happened. That made the legal and human stakes higher. Prosecutors built a case from material traces, DNA, messages, items hidden away, while judges and juries had to weigh motive with incomplete information. Families bore the worst part, a grief complicated by not knowing why. The unpredictability of silence also changed investigative priorities. With the defendant not cooperating, authorities had to rely more heavily on digital footprints and third-party testimony. Lines of inquiry that might have been quickly resolved by a confession or an explanation stretched into longer searches. In the community, silence allowed rumors to circulate, which is dangerous in itself. Every rumor can harm real people and distort real facts. So when Robinson finally spoke, his words did more than add information. They reshaped the context that his silence had created. That is why the months of quiet matter. They altered expectations, hardened positions, and made any later explanation more explosive because it had to address a long period of unanswered questions. A confession is inherently dramatic. It interrupts the legal process and forces everyone to reframe the story. Robinson's claim, that he was influenced or sent by another person, shifts the narrative from a single perpetrator to a potentially broader network of influence. When someone says they were influenced, several possibilities open up. Influence can be subtle, repeated persuasion, ideological grooming, emotional manipulation. It can also be explicit, instructions, payments, or promises. Robinson's wording, that he was sent, suggests intent attributed to an outside source, which prompts investigators to ask whether there was a direct orchestrator or a looser pattern of encouragement that nonetheless pushed him to act. For families and the public, this is both unsettling and, in some ways, relieving. If someone else bore responsibility, their grief might be shared across more people. Conversely, the idea that there could be additional actors is frightening because it suggests the threat may not be isolated. Legally, claiming outside influence is a double-edged sword. It invites deeper investigation into other potential suspects and may open the door to charges for accomplices or conspirators if evidence supports the claim. At the same time, claims of influence can be mobilized defensively, suggesting diminished culpability or coercion, without proving anything. Prosecutors typically respond to such claims by demanding corroboration. Is there electronic communication showing coordination? Are there witnesses who can place others in a planning role? Without concrete evidence linking a second party to the act beyond the defendant's assertion, influence remains an allegation. For investigators, the confession also raises tactical questions. Was the confession a strategic timing to negotiate plea terms, to direct attention away from certain facts, or to force authorities to chase leads that may or may not pan out? The complexity of influence, psychological, social, technological, means this claim cannot be treated lightly. It demands a methodical response. Follow the communication trails, search for financial transactions, re-interview witnesses, and recheck timelines to see where another person's involvement could realistically fit. For the public, the claim changes how they think about violent acts, not as isolated outbursts but as potentially emergent from relationships, groups, or networks that encourage destructive behavior. That shift matters because it alters both prevention strategies and how justice is pursued. Prosecutors typically build cases on a combination of motive, means, and opportunity, and in this case they argue those elements point to Robinson acting with intent. The evidence they cite, alleged messages discussing plans, physical preparations like hidden clothing and a stashed rifle, and DNA linking him to the weapon, reads as a record of deliberate action rather than sudden submission to someone else's command. From a prosecutorial perspective, the presence of planning materials indicates autonomous decision-making. One does not typically stash clothing or conceal weapons if they are simply acting under duress at a moment's notice. Similarly, digital messages that outline steps or map timelines suggest premeditation. Prosecutors will emphasize patterns that show consciousness of wrongdoing, efforts to avoid detection, to alter the scene, or to hide evidence. These behaviors are legally significant because they undermine claims of coercion or diminished capacity. If someone carefully prepared, the argument goes, they had the capacity to make choices and to foresee consequences. That makes it harder to persuade a jury that the defendant was merely a puppet. Prosecutors will also frame any post-arrest confession that points to another person as an attempt at blame shifting. In their view, saying, "Someone influenced me," after being presented with strong physical and digital evidence fits a familiar pattern, craft a narrative that spreads responsibility and hope for mitigation. The legal calculus is straightforward. To accept the idea of an outside actor, prosecutors need corroboration, communications tying the other person to planning, proof they were physically present or materially involved, or testimony that supports a directive relationship. Absent that, the confession risks being labeled a convenient story. This is not to say influence is impossible, just that the burden of proof falls on the defense to show it credibly. Prosecutors will therefore double down on forensic timelines, seek to authenticate messages, and present a cohesive narrative that the defendant acted on his own. The stakes are high because prosecutorial framing shapes public perception and can determine whether the case remains focused on a single defendant or expands into a wider inquiry. From the defense viewpoint, the confession that names an influencing party is central to a strategy aimed at humanizing the defendant and explaining his state of mind. Defense attorneys often emphasize context, who the defendant was before the event, what pressures he faced, and how relationships shaped his decisions. If Robinson's lawyers argue he was manipulated or coerced, they will likely introduce psychological, social, and relational evidence to show how influence can erode personal agency. This could involve testimony about his background, mental health, susceptibility to authoritative figures, or a pattern of submission to another's control. Defense counsel might also point to manipulative communications or power imbalances that made him vulnerable. The legal effect of proving coercion is nuanced. Successful coercion claims can reduce culpability or open the door to different charges, for example, from first-degree murder to a lesser offense if the defendant truly lacked volition. But proving coercion requires demonstrating a credible threat or undue influence that overcame the defendant's will. That is challenging. Courts demand more than simple moral pressure or persuasion. They require a degree of coercion that significantly impairs autonomy. To support their case, defense lawyers might call experts in psychology to explain how grooming or ideological radicalization works, showing how repeated exposure to persuasive rhetoric, isolation in echo chambers, or charismatic manipulation can lead someone to act against their prior patterns. They may also produce communications that show another person's persistent encouragement or instructions. Importantly, the defense also has to reconcile the parts of the record that look like planning. They may argue that what appears as planning was actually the product of a manipulated mind, that the defendant's steps to look prepared were driven by a desire to appear capable for an influencer, or to follow instructions perceived as essential. In public terms, the defense's narrative reframes the defendant away from being an autonomous villain toward being a person exploited by someone with more power or influence. That narrative can be compelling in the courtroom and among jurors, especially when paired with evidence of vulnerability or coercive dynamics. But it also faces the uphill battle of countering physical evidence and timeline inconsistencies that prosecutors will highlight. For investigators, a confession that implicates others is at once promising and problematic. It promises new leads, names to check, communications to subpoena, locations to search. It's also problematic because a defendant's statements can be self-serving, timed to influence legal outcomes or public opinion. Investigators therefore proceed cautiously, testing every claim against independent sources. They will triangulate, compare the confession to phone records, social media exchanges, financial transactions, and witness accounts. If Robinson names a person, investigators will check whether that person's presence, messages, or actions line up with known timelines. They will look for corroboration that goes beyond the defendant's words. Investigators know that false confessions, partial confessions, and tactical admissions happen, sometimes to shield someone else, sometimes to create bargaining chips. So they treat such statements as starting points, not conclusions. That caution has practical implications. It means reopening the casebook, revisiting forensic evidence with fresh eyes, re-interviewing witnesses who were originally only peripheral, and re-examining digital trails that might have been dismissed. It also means being prepared for complex follow-ups. If the named person is located, they may refuse to cooperate. If they cannot be linked to physical evidence, a prosecution may be difficult. Investigators must also manage public expectations. A confession that suggests wider involvement can trigger intense media and community pressure for immediate arrests. Law enforcement will resist precipitous moves until they have evidence that will hold up in court. Ultimately, investigators are trying to separate confession as fact from confession as narrative. They must determine whether the confession reveals an actual conspiracy or is a story told because it serves a defendant's legal aim. That requires time, methodical work, and a willingness to revisit assumptions formed during months of silence. In modern investigations, messages, posts, and settings on devices often carry as much weight as physical traces. The references to Discord messages, private texts, hidden clothing, and a stashed rifle, if accurate, paint a picture of preparation that's hard to dismiss. Digital evidence can show planning in granular detail, timestamps that map a sequence of steps, language that reveals intent, and networks of contacts that suggest collaboration. Those records are especially powerful because they are less prone to the memory lapses and retrospective edits that can affect human testimony. Likewise, physical actions, hiding clothing, stashing a weapon, indicate a consciousness of wrongdoing and an effort to avoid detection. Together, digital and physical footprints can construct a compelling narrative of premeditation. But digital evidence is not always infallible. Messages can be taken out of context, accounts can be shared, and metadata can be misinterpreted if not carefully authenticated. For that reason, forensic analysts must verify the origin of messages, ensure they were not fabricated, and confirm the identity of the sender. Similarly, items found at a scene or in a suspect's home require rigorous chain of custody documentation to be admissible in court. The tension here is clear. The defense will point to alternate explanations, account hijacking, misinterpreted messages, or planted evidence, while the prosecution will stress the weight of corroborating details. For the public, the presence of such records often feels definitive because digital trails seem objective. Yet the law knows that proving intent requires connecting those dots convincingly, demonstrating that the messages and hidden items form a coherent plan rather than scattershot activity. A criminal case is never only about evidence and law. It is also about people who lose loved ones and a community that must carry on with the knowledge that something terrible happened nearby. The shifting narrative in this case, from silence to confession to claims of outside influence, compounds grief because it keeps the wound open. Families who longed for straightforward answers now face competing versions of the truth, each with different implications for blame and closure. For some, the idea of another person being involved can feel like vindication or relief. Maybe the act was not entirely the product of one troubled individual. For others, it creates new trauma. The prospect that more people might have had a role in creating the conditions for violence is terrifying. Communities also wrestle with practical concerns, safety, trust, and how to prevent similar tragedies. When a case raises the possibility of manipulation, it prompts community leaders, schools, and online platforms to ask how influence operated and where warning signs were missed. The social ripple effects extend to first responders and neighbors who relive the day's events in public testimony, media coverage, and private conversations. All of this influences how the case is perceived and how people heal, or fail to heal, in its aftermath. One immediate legal consequence of a confession pointing outward is the potential widening of the probe. If Robinson's words are corroborated, law enforcement may open new lines investigating additional suspects, financiers, or facilitators. That could mean subpoenas, search warrants, and cross-jurisdictional cooperation. Expanding a case is resource-intensive and must be justified by evidence, yet it's necessary if the confession is credible. At the same time, an expanded investigation can change the legal calculus for all involved. Plea bargaining, witness protection, and the distribution of charges could shift. While enlargement brings the promise of fuller accountability, it also prolongs uncertainty for victims' families and the public. Beyond the specifics of any one confession lies a wider concern: how people, especially isolated or vulnerable individuals, can be swayed by ideas, communities, or persuasive figures online. Radicalization is rarely a single event. It's often a process where repeated exposure to toxic rhetoric, echo chambers, and targeted messages changes how someone sees the world. If influence played a role here, it underscores the urgent need for better digital literacy, community interventions, and early warning systems that identify when persuasion is becoming dangerous. This is as much a public health problem as a criminal one. preventing harm requires addressing loneliness, misinformation, and the mechanisms by which people become convinced to act violently. At its core, the story is a reminder that criminal events rarely exist in neat, single-person snapshots. Silence can conceal complexity, confession can complicate rather than clarify, influence can obscure individual responsibility while revealing systemic risk. The legal system must sort these layers carefully. Society must reckon with how persuasion and secrecy interact to produce violence. And families deserve answers that are thorough, accurate, and humane. This case forces everyone to hold multiple ideas at once, that a person can both plan and be influenced, that evidence can point one way while testimony suggests another, and that the search for truth is often slower and messier than we want. The confession changed the story but did not close it. It opened new questions about who held influence, how choices were made, and what responsibilities others might bear. For the families grieving, it complicated their search for closure. For investigators and prosecutors, it offered leads that must be tested against hard evidence. For the public, it highlighted how silence and persuasion can twist a simple narrative into something far more complicated. As this case moves forward, the crucial tasks are clear: follow the facts, corroborate claims with independent evidence, and keep the human costs at the center of every legal step. If you want real-time updates as the investigation unfolds, make sure you're subscribed and that your notifications are on. I'll keep watching the records, the filings, and the facts, and I'll keep you informed.